ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ. ಸರ್ವರಿಗೂ ಶರಣಾರ್ಥಿಗಳು. ಕೇಲಿ ಮಹಾವಿದ್ಯಾಸಂಸ್ಥೆಯ ಸಪ್ತಋಷಿಗಳ ಪಾದಾವೃಂದಗಳಿಗೆ ನಮಸ್ಕರಿಸಿ ಈ ದಿನದ ಅಂತರ್ಜಾಲ ಆಧಾರಿತ ಕಾರ್ಯಾಗಾರವನ್ನು ಪ್ರಾರಂಭಿಸುತ್ತಿದ್ದೇವೆ. I request all the delegates for better audio experience, please use headphone and mute yourself on your entry. If in case the delegates get disconnected due to any reason, he or she can rejoin with the help of same link provided. Dear delegates, greetings and good wishes to you all on behalf of Keli SNC Parivar. We always wish for your good health and beautiful smile. Let's break the chain and stop the COVID-19 spread during this challenging time. We need to tell our loved ones that we care them a lot. We need to protect ourselves and all those around us by breaking the chain and preventing the spread of COVID-19 virus during this pandemic situation. Dear delegates, get vaccinated at first opportunity. A simple precautions will keep us all safe and secure. Now it's time to wake up and mask up. Maintain the proper social distance and break the chain. All the participants are requested to fill the feedback form which will be shared on second day of the workshop. Queries can be put only through the chat box with participant name and affiliation. All the queries will be answered at the end of each session. The host will ask queries on behalf of with your name and affiliation. At the end of workshop, we have planned for the group photo session. We request all the participants to stay tuned with us till the end and join us for photo session by switching on video. A warm good morning and cordial welcome to one and all present here. This is Dr. Pratibha KS, Head Department of Biotechnology. Distinguished inaugural speaker, invited guest speaker, principal, IQAC coordinator, heads of various departments, esteemed colleagues and delegates. Before proceeding towards today's virtual workshop on intellectual property rights and biotechnology in association with Karnataka State Council for Science and Technology, it's my great privilege and honor to introduce briefly about our institution, Keli Society and S. Nijlingappa College to today's speaker. Keli Society is one of the prestigious and largest educational society not only in India but also at a global level under the dynamic leadership of our Honorable Chairman Dr. Prabhakar B. Koreji Sir. The society proudly manages with elevated number of institutions up to 270 in various fields of education, including research in India and abroad with quality concept. Dear luminaries, our Keli Society's S. Nijlingappa College is affiliated to Bengaluru City University and accredited by NAC at A+ grade college with UGC State Component 1. Yes, Nijlingappa College is offering science, arts, commerce and various management courses for the benefit of students' fraternity. Yes, Nijlingappa College has been forefront in organizing many virtual programs for the benefit of academicians, research scholars, faculty and students. The main sole purpose of two-day virtual workshop on IPR and biotechnology is to focus on different aspects of intellectual property rights and also to ignite young energetic research mind towards recent trends in patenting related to biotechnology and also on overview of IPR, PGR, GATT, copyrights and protection and also related to biotechnology. Very shortly, we are entering to do MOU in association with KSCST to encourage our research mind. In this regard, today and tomorrow, Department of Biotechnology in association with Karnataka State Council for Science and Technology organized two-day virtual workshop on intellectual property rights and biotechnology. Today and tomorrow, we have invited eminent guest speaker who have highly enriched research knowledge towards IPR and biotechnology. We hope every young and energetic mind will utilize this rare opportunity for their benefit. Dear luminaries, now I would like to request Srimati Pallavi Prasad MS, Faculty, Department of Biotechnology, to proceed with today's inaugural ceremony of IPR and biotechnology, followed by technical session 1 and 2. Over to Srimati Pallavi Prasad. May I have Pallavi Prasad?
Yes, ma'am. Very good morning to one and all present here. On behalf of KLI's Yes Nijalingappa College, I, Pallavi Prasad, Assistant Professor, Department of Biotechnology, wish to extend a warm welcome to all the delegates, distinguished guest speakers, dear colleagues, and participants. I would like to thank you all for allocating time in your busy schedule to attend this IQAC initiated 2 days virtual workshop on intellectual property rights and biotechnology. To welcome is to show honor. To welcome is to establish integrity. I request Dr. Pratibha KS, Head, Department of Biotechnology, to formally welcome and introduce the chief guest of today's event, Mr. H. Hemant Kumar. Over to you, ma'am.
Thank you, Thank you, Srimati Pallavi. Ladies and gentlemen, it's a great privilege to welcome you all to today's workshop on IPR and biotechnology, organized by Department of Biotechnology in association with Karnataka State Council for Science and Technology, initiated by IQAC KLE Society's S. Nijalingappa College. Now, I would like to welcome today's chief guest and keynote speaker, Mr. H. Hemant Kumar Sir, Executive Secretary, KCST, on behalf of KLE Society's S. Nijalingappa College, management, principal, heads of various departments, esteemed colleagues, and also on my personal behalf, we welcome you, sir. Thank you for joining us, sir. Thank you. Now, I would like to welcome Honorable Principal Dr. Arun Kumar B. Sonapanawar, who is the driving force behind all our S. Nijalingappa College various programs. On behalf of Department of Biotechnology team and KLE SNC Parivar, we welcome you, sir.
Okay. Thank you, madam. Thank you very much.
We also welcome IQAC coordinator, heads of various departments, esteemed colleagues, delegates, and students to this virtual workshop on IPR and biotechnology. It's my great privilege and honor to introduce today's chief guest, inaugural speaker, keynote address of 2-day virtual workshop on intellectual property rights and biotechnology. Mr. H. Hemant Kumar, Executive Secretary, Karnataka State Council for Science and Technology. Sir joined the council in the year 1985 as a project engineer and has a postgraduate degree in civil engineering from Bengaluru University. He is currently investigating the Karnataka Natural Data Management Systems, that is NRDMS program, State Spatial Data Infrastructure Project, and various programs besides few other projects. To his accomplishments, Sir has published more than 25 journal and also conference papers and has delivered several keynote and technical talks at national and international platforms. Sir, he is a member of several expert, also technical committees, to name Committee of Department of Science and Technology, Government of India, National Biodiversity Authority, Department of Biotechnology, Kerala, Jammu and Kashmir, Odisha, Haryana, Government of Spatial Data Infrastructure, BBMP BDA, Ministry of Human Resource Development, MHRD, University of Agricultural Science, Bengaluru, Advanced Center for Integrated Water Resources Management, that is ACIWRM, ATRI, Karnataka Watershed Development Department, National Data Registry, BIS, many more. He has also head the Technology Innovation Support Center, that is TISC, along with the Patent Information Cell of KACST, and guides in conducting the IPR programs and development of IP ecosystem at the Council. His area of specialization includes geospatial technologies, spatial data infrastructure, alternate building technologies, watersheds, minor irrigation tanks, e-governments, many more. With this brief introduction, I present before you Mr. H. Hemant Kumar Sarji, Executive Secretary, Karnataka State Council for Science and Technology, to inaugurate today's session. Over to you, sir.
So good morning, all. It's a virtual inauguration, and I'd like to speak for 2 minutes regarding my council and what we do in the council in terms of promoting IPR. My council actually started way back in 1975. Basically, it's an initiative of Indian Institute of Science and the state government. And we were the first councils to be established in the country, apart from Punjab and Kerala. And we have a very good uh, support from both government of India and the state government. The objective of the council is to take the S&T interventions or innovations or S&T benefits to the state government, and whatever technologies that gets done in the R&D institutions, not necessarily from Indian Institute of Science, it could be any academic institutions across the state or the country, which benefits the people and also the state. For your understanding, you know that
Sir, we are unable to hear your voice, sir. Hemant, sir, we are unable to hear your voice.
to build an ecosystem in each and every institution in the state, so that some of the ideas or inventive ideas or innovations or the novelty that we have gets used by the people. Otherwise, having so many academic institutions, uh, and I personally believe that academic institutions are not just for teaching, it's also meant to do research and some sort of a development, and the benefit should reach the society. Otherwise, people do certainly think these many R&D institutions uh, should make someone's life better. That's the whole issue. So the council looks into that, and so far we have done exceedingly well in several areas, especially in terms of water, energy, technology, housing, and so on and so forth. Uh, my council is, headed by Chief Minister. That's the general body is headed by the Chief Minister. Apart from that, we have 3 presidents and 41 members. And we have an executive committee which guides and provides us advices on issues related to projects and program, and also provides vision and mandate for the council. So here I'd like to specifically mention that our executive committee is headed by Director in Digital Science. Normally, these are the posts which is occupied by a bureaucrat, but in our case, in our council, this is uh, from the beginning. It's Director in Digital Science heads our council, which makes us apart from other councils in terms of disseminating S&T inventions, innovations, technologies, and products and services. I think this is a wonderful concept, and we are blessed with the support of Indian Institute of Science and other R&D institutions, and the working atmosphere here in that council is wonderful, really good. In terms of somebody wants to make a difference, definitely can do. This is because of the academic touch and also the support from both the state and central government. And I would like to mention some of the projects that we do and some details about it. GIS and remote sensing is one area which we are doing from almost 3 decades now. And you may be aware that Google Maps have been exceedingly used by almost all of us, I think, in terms of finding locations or place of interest. But for developmental planning, we need beyond this place of interest or location. We need to know where exactly our resources are placed and what is the type of soil or land use, land cover, what exists on the land, and what type of crops and these, where are the forests, where are the nalas, where are the water resources, things like that. And 30 plus development departments in the state, around 18 to 20 departments definitely depends on maps for decision making. And our state is the first state to use technology for decision making. And even all the action plans that what you see from different departments, that is agriculture, horticulture, so on and so forth, they use our maps on a day-to-day basis, and it's embedded into the governance process. That's very much important. See, there are two kinds of usage. One, I use it when I like it, but when it's embedded into a process, that means technology is here to stay. And ours is the first state to embed geospatial governance in the state. This is a very, very good beginning for us. And we have many programs like water. I think you're all very well aware that our state, apart from Chennai, is the first state to bring a rainwater harvesting policy in 2009. We were very much part of it, and we drafted the RWH policy. And we've been working for almost 1.5 to 2 decades here. And we conduct a lot of programs to help and capacity build engineers, architects, and plumbers. So far, we have trained more than 2,000 plus plumbers and engineers. In fact, BWSSB mandates that anybody who wants to get a plumbing license in Bangalore has to go in for a mandatory participation in our RWH training program. So this is mandated. And mandated by law also, anybody who builds a house in Bangalore has to have a RWH installed. So far, 1.6 lakhs plus RWH have been installed in so many dwellings. And recently, there's also enforcement we have started. This is basically in association with Bangalore Water Supply and Sewage Board. And we also work on drinking water, water body restoration, and watershed development. We continuously and constantly support the state government in monitoring, evaluation, letting, and documentation of all these programs, especially water body restoration. Our reports have been used by the state government in Jalashakti Abhiyan and Narega programs. And next one is education. I think we've been supporting engineering students, projects, secondary engineering since 1977. This is the 44th year. So far, we have supported more than 13,500 projects, and many of them commercialized. And from past 3 years, we're also looking into getting patented for some of the projects which have been awarded. So this is one thing. And apart from that, we also support the faculty research projects. Suppose somebody, students and faculty does something, and it requires fine tuning and tweaking, and requires some amount of financial support to make it commercially viable. So to that extent, we also do that supporting. And from this year, we are doing that. And housing is also one area which we been engaged from 4 decades now. We have many alternatives in walling and roofing elements. We have more than 20 plus varieties of walling and roofing elements which can be used. And in Bangalore alone, more than 20,000 dwellings have been using our technology, which essentially means that close to 20,000 crores of investment gone in our using our technology. And mind you, all these dwellings, all these dwellings are individually owned. None of it is government owned. That means to say that 20,000 happy users, happy citizens, because of the work and the effort just gone in industrial science and my council. We also work on energy. That is current technology is bioenergy. That is blending of diesel and petrol. As you're all aware that these fossil fuels are going to end someday. So we have started using the non-edible oil seeds and ethanol for blending petrol and edible oil seeds for blending diesel. And we have a national policy on biotechnology 2018, which makes certain things mandatory. And we are helping the state through Karnataka Bioenergy Development. So that's one area. And we also do a lot of detailed project reports and things like that to government institutions and private institutions on establishment of solar 1 megawatt. We are doing it in few places. We provide detailed project reports for that, and many such programs. And I'd like to now come to the today's topic of IPR, and we've been in this field for almost 1.5 decades. And let's begin with what is IPR? IPR, protects your intellectual property, not necessarily patents. It could be many things. It could be copyrights, trademarks, designs, geographical indications, plant varieties, all of it which comes under IPR. But let's begin with patents. And what's a patent? To put it in a right way, patent is granted to any individual for an invention, which could be a product or a process that provides in general a new way of doing something or offers a new technical solution to a problem. To get a patent, the inventor has to totally disclose to the public during the filing of the patent application. What kind of protection does a patent offer? This is often asked by people. See, basically it protects you and gives you the exclusive right to prevent or stop others from commercially exploiting the patented inventions. If I have an idea and if it's not patented, others can use it because no one has claimed it. So patenting means I have claimed the innovation and patented it, filed, published, and granted patent. That means to say others can't exploit it unless I give them exclusive right to or license it to someone to use the patent or the idea. So in other words, patent protection means that an invention cannot be commercially made, used, distributed, imported, or sold by others without exclusive patent owner's consent. This is very, very much important. And generally people do ask, is it valid? Yes, it's valid in the country where you apply only. So it gives you the exclusive right in that country. However, now we have the PCT Act, which also gives you the exclusivity across many countries who have signed the PCT, that is patent treaty. How long does a patent last? Generally, it lasts for 20 years from the date of filing. Now, coming back to the PCT, that is Patent Cooperation Treaty, that's basically WIPO, the World Intellectual Property Organization. It's a body at the world level, which all of us are members, every country is a member. And this WIPO actually helps us, every country, every cells like us, to perform better. They provide you a lot of inputs. If you go to the WIPO website, I think you get lots and lots of information, and you get to know the patents filed in different areas, domains, and things like that, year-wise, subject-wise, domain-wise. I think there is lots of, I think some, those who are interested should definitely see that. And what does the Patent Cooperation Treaty means to all of us? It assists applicants in seeking patent protection internationally for their inventions and helps patent offices with their patenting granting decision and facilitates public access to a wealth of technical information related to those inventions. This is very much essential. And by filing the international patent application under the PCT, applicants can simultaneously seek protection for an invention in large number of countries. This is very, very important for us. And also the International Bureau interprets COVID-19 pandemic as falling under the PCT excuse of delays provisions and recommends modified practices to PCT offices. So what does KCST or the KCST IPR will do exactly here? Our job is to see that to create awareness on intellectual property rights, especially on patents, since we are coming from R&D institutions, and we do patent searches. I mean, what exactly is a patent search? See, suppose I have an idea. I would like to know now, does that idea has already been patented or filed or something like that? So I go for a prior art search, it's called a patent search, which enables and tells me similar kind of patents already been filed and gives me the claims that's been made. Now it's my job to not to repeat the claims already been made and make other claims which are not been done so far. This is very much essential for filing a patent application. So this we do it for all the faculty, students, startups, and industry. This is our job. So we do it well, and this is done by, we have an excellent advisors and subject experts with us, apart from the in-house expertise we have. Mr. Vivek, Mr. Nagarjun, they take care of most of the things. We have a very good support from our subject experts. They do this. And tomorrow they will be speaking to you as well. And today also, after the inaugural session, they will be speaking to you. And we guide the inventors in patenting the invention. And one of the important things that we do is setting up IP cell and each and every unit. This I would like to dwell it slightly further. I think KLE society definitely needs an IP cell. And this is very much essential, and this should happen at the earliest, not just for
Hemant sir, we are unable to hear you, sir.
dealt with to the students and faculty. And we do hope that these workshops or webinars or whatever we call it as will act as a boost for the faculty and students to at least start filing patents. Otherwise, this two-day program is not just for information, it is for action. I repeat, it is not just for information, it is for action. That is, we need to take this beyond this today. We should be making this part of the daily society's institution. And probably we extend slightly beyond that. We need to have an incubation center and also a startup if possible. The management agrees for it. And our cell also provides IPR protection for innovative projects, which are being carried out under the technical institutions, especially graduate and postgraduate engineering institutions. We also encourage interaction between academia and industries and bring them to a common platform so that commercialization of innovative projects could happen. These are basically the core objectives. And I think all of you, after setting up the cell, you should read the IPR policy of 2016. I think we have a lot many things in store for us compared to the policy that we had earlier. This new policy actually reduces the time taken for filing to granting from 5 to 7 years to 18 months to 34 months, something like that. That means to say that earlier we used to take a lot of time during the date of filing to granting. Now it's been reasonably reduced. So reduction in approval of trademark applications, the current average is 13 months to 1 month. I think it's a tremendous growth. Government is doing at its best to create a robust IP ecosystem in the state as well as in the country. I think all our institutions and including myself should support the initiatives of the government and see that the state and the government of India, the country as a whole should be a knowledge society. And we should be on par with the developing country. That's the whole issue in promoting IPR. And also conflict resolution, it's much better compared to earlier. And the policy review, I think it's happening now every 5 years with the stakeholders because it's always a dynamic situation in IPR. We need to change with the changing times. Otherwise, you cannot apply the old theories now. So there are a lot many things happening after the IPR policy that was brought in 2016. I think many more things will happen in the coming 2-3 years. And for information, I think KCST website has published many books, and it's also available on KCST website. You can also Google search for information about IPR, but you can also get many information from website. I think you just type KCST and you get to the homepage. From the homepage, you can reach the patent and you can download. It's both in the local language in Kannada as well as in English. I think this is a very good effort from our side, providing information a lot. But this is the present world. I think the Google search you get practically everything. But however, you can also refer us. And recently, what we have done is we have established Technology Innovation Support Center with the support of CTAM, that is Center for Intellectual Property Management. This is the 8th center. What it does is it's to be installed now. It provides access to online patent and non-patent resources. It provides access to industrial property related publications.
Hemant sir, we are unable to hear you, sir.
Never thought that they could file patents because they felt that patent is for somebody who is a very high IQ or somebody who is a geek or something. It's nothing like that. And now colleges are coming with 20 patents, 40. Some of them have 200 in mind. They have a target of 200 per year. I think Haley being the oldest college in the practically, in fact, I studied in Haley during 79, 80s. I think they should promote this IP culture because being the one of the oldest college like Sheshadipura and US colleges, I think they must, and hopefully this kind of things will help them in doing that. And don't worry, you don't have to be a great scientist for that. Your idea should be climbable and there should be some novelty in what you do. And it should not have been thought by someone else earlier. These are the prerequisites. And this kind of webinars and workshops will definitely help the institutions like Haley or any other college in Bangalore or any place in Karnataka as such to take patent in a big way in future. And to promote this IP culture in the institutions, we do conduct many programs today. We're conducting this program for today. Generally, IPR will be aimed at basic understanding of patents, designs, trademarks, copyrights, GIs. And if you go slightly deep into it, that is, if the faculty students want much more information, then there will be webinars or workshops for drafting patent procedures and filings, then designs, filing procedures and infringement cases, then trademarks, case studies, copyrights, plagiarism, infringement, research ethics, things like that. Geographical indications, that is importance and registration procedures. I think Karnataka is one of the highest number of GIs. I think Nanjangud, Bode, or what you can say, Chenpata, all this. And we also have slightly bigger programs, 3 days, 5 days, or 15 days. 10, 15 days is mostly for PRR search and things like that. And we do conduct faculty development programs, short-term training programs, and it could be infringement, startups. We do have a small program for IP for startups, commercialization, hands-on training on PRR search, quizzes, assignments, and certification. And I think all this and much we do on IP student projects every year, as I already told you, award about each 200 best projects, and we try to file at least few of them which are novel, try to file on behalf of them and see to it that it's commercialized. So now here the point is, we would like to see that the KLE has an IP cell and also promote this IP culture inside the college. If possible, they should have an incubation or a startup facilities within the college, because this is basically looking into making our self-sufficient, and the goals of the government of India is make in India, skill India, things like that. We need to support that. Instead of job seekers, I think the East institutions should produce students who are job givers. That is possible through I think we need more and more of job givers than job seekers. That could definitely happen through IPR. But if your college management and the principal, faculties, and all of them stick to this mantra, probably at some point of time, we'll have many more startups coming from your institutions. It will be a proud moment even for the marriage. And lastly, we have a good collaboration with many institutions, organizations, and starting from Department of Science and Technology, Government of India. Then as I told you, CPAM, that is Cell for Intellectual Property Rights Promotion and Management. Then we work with KCTU, Karnataka Council for Technological Upgradation. Then we work with VTPC, National Law School, KITS, Karnataka Innovation Technology Society, then NRDC. And recently, you may be aware that we have invited applications for the IP awards. That is for the best under this category of students, faculty, institutions, and startups. We shortlisted few of them. Probably this month we are honoring them for doing exceedingly well under different categories. And hopefully by next year, KLE College stands a good chance of getting an award by filing patent or by conducting a lot many programs like this and enthusing students and faculty the benefits of IPR and the promotion of IPR. I think at this time I would like to stop at this point. Back to the college, back to Madam. Please, my job is done. Yes.
Thank you very much, sir. The best leaders not only inspire us, but develop and empower us to lead with passion. I take this opportunity to welcome our respected principal, Dr. Arun Kumar B. Sonapanar, to develop the presidential remarks. Over to you, sir.
Thank you, Pallavi, sir. Good morning to all the dignitaries and all the participants who are actively going to participate and interact with the resource persons on this, the occasion of 2-day an interactive workshop on intellectual property right and biotechnology. So, paying my deep sense of the salutations to the Saptarshis of KLE Society, I feel very proud to have the program of a special program, I can say, that is on IPR. So, today's the chief guest and the keynote speaker, Mr. H. Hemant Kumar, Executive Secretary, Karnataka State Council for Science and Technology, and even the resource persons, they are going to participate in this program, and all the HODs and coordinators of various departments of the college, and the delegates from our college and even from other colleges, and my dear student friends. It's really a wonderful morning that we have arranged this program where our students are get a great expose to the new era, that is getting a patent for any kind of the innovations, whatever the young students or scientists or the faculty they are doing. So today's the chief guest, Mr. Hemant Kumar, he has elaborated how that the Karnataka State Council for Science and Technology has involved since from many years, more than 40 years, that council has involved to make the youngsters, especially the academicians, and to get a bridge, to make a bridge with the industries, and how to get protected our intellectual, the ideas or the properties. So it's a protective, the measurements for all the academicians or the researchers or the students who are willing to join the field of research. Sir, this is the very prestigious college of KLE Society, S. Najlingappa College, which is offering about 23 subjects. There are about 8 UG programs we are having, and 7 PG programs we are having, and including with the affiliation and recognition by the Bangalore City University. Very recently, sir, we are applied for UGC. No doubt, since in the entire history of the college, we utilized the number of funds from the different agencies like UGC or DST or the DBT. So all the funds we are used, a number of our faculty and even the students, they are engaged in the process of research, and they have produced a number of very good research papers with a very high impact factor. No doubt, we are all very good academician researchers, but the only one, the lacuna which was there since the 60 years of this history of the college, that is patenting. So I think probably you are now going to fulfill that our dream, that whatever academicians they are also thinking are willing to have a patent for their whatever the achievements or the progress they have got in their research. Recently, we have got a fund from UGC that is to develop a research capacity building of the teachers and also the human resource development. So it's a very good occasion, I can say, or a platform, I can say. So you are educating us how all we are already involved in the process of research, no doubt, but getting the patent for that, even it may be the service or maybe the protocol or maybe the product. So totally we are uneducated in this regard. So probably if you are, even I can say very openly, I invite you, sir, I request you, please give us a kind of collaboration so that together we can progress, we can march ahead, and definitely that will help us because we have about 3,500 student community in our college, and even we are very much associated with our sister institute, the College of Pharmacy, and even the other our sister institutions are also ready to join or to put hands together to work with you people and regarding this the process of the IPR. So especially in biotechnology, I can say, sir, in our KLE societies, more than 272 colleges are there. Very recently, our society has started the Cancer Research Center and Special Research Center on the biotechnology, and number of our faculty members are already working. And very recently, our Ayurveda college also got very good appreciation from the international academicians regarding some of the drugs they have invented. But still, our KL institutions, they have never got a chance to get patented. So definitely, sir, your council will help us, the KLA society. Even I request you to have a good collaboration with the entire KLA society. Definitely, we are there with you, and we'll put our all efforts to see that our researches will be get identified by in the national or international way. So this is a very great opportunity, and you have given a lot of information how your council is working, and you are really motivated. Even all our student friends are also, because students are learning only for the process of getting graduation, post graduation, or PhDs. But nobody thinks about that. How we can go for the patenting? How we can get a benefit out of that? So really, you have elaborated and you have emphasized a lot of ideas about this IPR. It was a great informative information for all of us, and even I also request my all the participant and student friends, the 2 days this the workshop what we are conducting, definitely that will help you, and please involve in that, and practically you can think about that, and take the help of the council and get the very good patents or the license for any kind of the achievements what you are doing in our academic ideas. So with this, I wish our organizing Department of Biotechnology and all other the student friends a great success for this the 2 days the workshop, and get out of this a very good positive response, and please implement these ideas in our the college system so that we can develop a ecosystem of the scientific temper research and the patenting. So for this getting an opportunity to participate in this program, that too with a very applicable technically applicable the session what Mr. Hemant Kumar he has given. So wonderful information, sir. Once again, I welcome you, and I wish you all the participants a great success for this 2 days interactive workshop. Thank you once again, one and all.
Thank you very much, sir. Gratitude is the most exquisite form of courtesy. Saying thank you is more than good manners. It is good spirituality. I now invite Dr. Savita V. Patil, Faculty, Department of Biotechnology, to propose the vote of thanks. Over to Dr. Savita.
Thank you. Good morning to one and all present here for the IQAC initiated 2 days virtual workshop on intellectual property rights and biotechnology on 4th and 5th August 2021. Today, I, Dr. Savita V. Patil, Assistant Professor, Department of Biotechnology, take the opportunity to put my gratitude into words on behalf of Department of Biotechnology, KLSNC, Bengaluru. I record my thanks to Almighty for enabling us to connect from far off distances in this tiring situation to participate in this webinar. We extend our sincere thanks to the invited chief guest and keynote speaker, Mr. H. Hemant Kumar, Executive Secretary, KSCST, for sharing his valuable thoughts on IPR, encouragement on applying for patents. Sir, we also thank you for throwing a light on KSCST's role as being a catalyst to promote innovation and patenting. We thank respected Principal Dr. Arun Kumar B. Sonappan, our KLE SNC, for his support on organizing this 2 days virtual workshop in association with KSCST Karnataka for his presidential remarks. We extend our gratitude to Dr. Mahananda B. Chittavadigi, IQAC coordinator, for her support. We thank wholeheartedly Dr. Pratibha KS, Head Department of Biotechnology, for her untiring involvement in organizing the webinar. We extend sincere thanks to various department heads, coordinators, and esteemed colleagues for making the inaugural ceremony a grand success. Also, we extend our sincere thanks to the delegates of different institutions all over the country who have registered and are attended in this webinar. Last but not the least, we thank our students for the enthusiastic involvement in this webinar. We thank each one of you for your presence. Thank you.
Thank you, ma'am.
1 second, Pallavi. Thank you, everyone. We request all the participants kindly switch on your video for 30 seconds. We'll just take a group photo. We request all the participants kindly switch on your video for just 30 seconds. We'll just take photograph. We'll take just a screenshot. Okay. Over to Pallavi. Thank you, one and all. Thank you, Hemant sir, for joining us and gracing this occasion. We are so blessed, sir, and we express our sincere thanks and gratitude on behalf of KLE Society's S. Nijalingappa management, sir. Thank you very much, sir.
Thank you, ma'am. With this, we wrap the inaugural session and move on to the technical session. I now request Dr. Savita V. Patil to welcome and introduce the speaker of the technical session 1, Dr. Sarasija Padmanabhan. Over to Savita, ma'am.
Good morning, one and all present. Good morning to one and all present here. For the IQAC initiated 2 days webinar on intellectual property rights and biotechnology on 4th and 5th August 2021, organized by Department of Biotechnology in association with Karnataka State Council for Sciences and Technology, KSCST, Bengaluru. Today, I, Dr. Savita V. Patil, Assistant Professor, Department of Biotechnology, take the opportunity to put my gratitude into words. I take the opportunity to welcome Dr. Sarasija Padmanabhan, a technical speaker for for technical session 1 for
May I have Dr. Savita, please? Dr. Savita?
Sorry. I'm glad to introduce today's resource person of Technical Session 1, Dr. Sarasija Padmanabhan, Patent Agent, Bengaluru, and Advisory Member of PIC, KSCST, a consultant, architect invent, BAS Law Firm, New Delhi. On behalf of KLE Society Management Principal, KLE's S. Nijalingappa College, Faculty of Department of Biotechnology, and on my behalf, I extend a warm welcome to Dr. Sarasija Padmanabhan. Dr. Sarsija Padmanabhan has the following educational credentials with a PhD degree in molecular biology from Shamyakin Institute of Bioorganic Chemistry and Molecular Biology of Russian Academy of Sciences, and a postdoctoral fellow from Molecular Biophysics Unit of IIC Bengaluru. She also has completed her Bachelor's of Law from Annamala University, Tamil Nadu. She is formally She brings over 18 years of incisive experience in IP space across diverse technologies, spanning pharmaceuticals, medical devices, molecular biology, organic chemistry, and material sciences, with special interest in green and smart innovations. Besides consulting for IP facilitations, firms like Architect Invent and BASC located in New Delhi and Cambridge, Sarasija ma'am involves herself passionately with the Indian government's mission of spreading IP awareness within the country. Under the aegis of Vishveshwaraya Trade Promotion Center, Bengaluru, and KSCST, she had participated in bringing awareness to numerous schools, colleges, and India's micro and small medium enterprise MSMEs. She had been a study winner in more than 3 crowdsourced study by Article 1 Partners, one of the largest patent search companies in the world. She also has won numerous in-scope awards. Recently, she participated as an individual contractor in a collaborative effort to prepare a guide of identified inventions in the public domain by WIPO and continues to participate in the efforts made by WIPO Match. Now, she is also a tutor in WIPO e-learning platform. Dear ma'am, Dr. Sarasija ma'am, this is the platform is yours. You can continue with the technical session 1.
Thank you so much. That was a really warm welcome. And I hope, you all benefit from this. I understand that the focus is biotechnology. And I would like to start with just a question. How many of you understand what the patenting scenario in biotechnology is? Can we patent a diagnostic method? Can we patent a research method in biotechnology in India? Since this, you have,
ಅವ್ರದ್ದು ವಾಯ್ಸ್ ಮ್ಯೂಟ್ ಆಗಿದೆ.
So can I have your views in the chat box, please? Or you can unmute yourself. Let's make it interactive so that, we discuss it instead of me giving a monologue on a perspective. Let us talk about it. So basically, does anybody want to tell me the answer to this? What does the law say? What does the IP law in India say about biotech? It would be nice if somebody gave me their, whatever it is, doesn't have to be 100% exact. It can be your opinion. whatever you think about it, you can tell me what it is. See, biotech is a very, very big umbrella term, right? It includes a whole lot, from medicine to horticulture, agriculture. It includes everything in its ambit. Now, what our law says, there is a section 3 in our Indian patent law, which tells us about things which cannot be patented. All right. So in that, the exclusions are, methods of agriculture, methods of horticulture. You cannot patent an animal. You cannot patent a living organism unless there is human intervention and you want to specifically show, that there is a particular hardware or a device involved. Methods of diagnosis, methods of treatment, therapeutic methods, surgery, all these things are not patentable in India. Specific exclusions from patenting. So how would you go about patenting when you are involved in biotech? Any answers? The topic is such, it cannot be a monologue. I would require interaction. So I would urge you to put your answers so that we can have a two-way, interaction, a conversation. So I have given you the starting point, section 3 of the Indian patent law, right? So in that, there are things which cannot be patented. In that, you have all these special exclusions. Okay, so why was this done and why was this made? The answer is very simple. These are very important for the common man, right? And you cannot be giving a monopoly on a therapeutic method. It needs to reach the common man, and that has to be available, right? Methods of agriculture, it has to be available. Exclusivity or a monopoly granted on these things makes the whole idea of patenting totally redundant. Patenting means, if you go etymologically, patent is the opposite of latent. Latent is that what is hidden, and patent is that what is laid open. And now what happens is, when in the process of filing, if you've heard about what the process of filing a patent is, you have to completely disclose what your invention is to the patent office. In exchange, what do you get from the patent office? You get 20 years. Now, these 20 years are very important. 20 years of exclusivity to operate, to work that application, whether granted or in the process of prosecution. 20 years from when? 20 years from the date of filing. So if the examination process, if that takes 4 years, those 4 years are cut, right? It doesn't mean that you will get 20 years from the date of grant. No, it is from the date of filing. So you can start operating and say patent pending. This is possible. Also, if your diagnosis, your method of diagnosis or therapy or whatever, it is included in a hardware, that is also patentable. Pharmaceutical compounds, these are patentable. Okay, now a method of therapy, a method of diagnosis, a way of doing surgery, a way of doing agriculture, a way of doing horticulture, these are not patentable subject matter. Animals, plants, these are not patentable subject matter. Now, can I have some answers, please? Why is, supposing you discover a new plant, why is that not patentable, please? Can I see some answers? Any answers? What do you think? Why are plants or animals which are discovered not patentable? No answers? Oh, okay, then I'll continue. But I would really appreciate if you interact. Natural resources are for all. That is a beautiful answer. That is very correct. But the actual reason is in the mechanism of patent filing, there are three filters. Those three filters being novelty, right? Inventive step and utility. Novelty meaning that it has to be something new. Now, if you are talking about a plant or an animal which is a natural resource and exists in nature, that means it's not new. You have discovered it. A discovery is not the same as an invention. Discovery means it already exists and you found it out. So a discovery is not patentable subject matter. It already exists in the prior art, right? So that is the reason why you cannot patent an animal or a plant that exists in nature and you find it. However, if you have made a plant or an organism, let us say by some manipulation, a genetic manipulation, right? And it brings about a change in the sequence in the DNA or something, and there is a different kind of an advantage in the crop. Now, would that be patentable subject matter? Would the filter of novelty, inventive step, and industrial applicability, will these filters, be properly passed by this invention? Any answers, please, in the chat box? Yes, that is correct. However, the national laws of the various countries, they always reign supreme, and each country has its own national law. The laws are not actually, they are trying to harmonize them, but they are not, they are different. Each country has its own circumstance, each country has its own way of dealing with intellectual property. They differ. All right. And patents are territorial in nature. Can you explain what does that mean? What does it mean when I say a patent is territorial in nature? Brilliant answer. So that is what it means. Wherever it is filed, that is where you will get the protection. Let us say you file for a patent in India. Will you get protection for it in Brazil? Will somebody in Brazil be able to use it? That is what I mean to ask. You have filed for patent protection in India. Would somebody? No, absolutely not, because the government in India will give you the protection, right? Brazil can make, use, or sell, but can they file for a patent in Brazil? The same invention. Can they file for a patent for the same invention? Any answers, please? No, they cannot. No, 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 absolutely not. The criteria of novelty is absolute, right? So the examiners have access to the best databases and best resources to find out whether your invention is new, whether it has been filed for in any other country. So the novelty filter, that will kill your application. So these are the three filters which you have to be very, very aware about, novelty, inventive step, and industrial applicability. Novelty you might pass. Now, what about inventive step? What does that mean? Any answers? Process. Okay. Any other answers? Okay, so inventive step is like that. Let us say an examiner looks at your invention and passes it through the novelty filter. Okay. Then he examines the literature that is available and sees there are two articles, let us say IEEE and chemical, let us say which one? Trends in biotechnology. Okay. And if you combine these two, it becomes very obvious. You can come up with this invention. But they have not been combined so far. But if you look at these two documents, it is very obvious that if you combine, you can combine it and you can get this result. So would there be an inventive step in such a case? would there be an inventive step in such a case? Not completely, absolutely, because anybody who is skilled in the art and is presented with these two documents would see that there is a possibility of combination, and that's what the examiner will do. He will put these two documents in front of you and ask you this question in the course of the patent prosecution, that these two documents exist in the prior art, and I believe that they can be combined and it kills the inventive step of your invention. So this is some of the little things which one comes across, and I'm just sharing it with you. The topic, today's topic, is not the basics of patenting, but you need to know a little bit before I can delve into the global scenario of biotech patents. So that's the reason I'm just giving you a little bit of prior background. Okay, so now let us look at what is available in patent databases. Patents are classified they are given a classification. Library books are classified. There are classes. Okay, so now I want you to see this um, um, website, which I am going to show you now. I will share with you here. Okay, so this is the one which I want you to look at. Are you able to see my my screen? Okay. Now you see, we are going to look at what is the global scenario of a biotech patent. So what do you do? Okay, I have selected medical technology over here. All right. So what countries do we want to look at? Okay. So if you want to look at India, then you just have to type India here. So let me just close all this. And I'll just put India here. Okay, and I am going to look for medical technology from all these. Okay, so now let us medical technology. I just need to go and do a chart type. I'll do this chart type line. So here is all the medical technologies you can see. Oh, all it says, it comes to all again. It's not kept India. Okay, so here is, again it went, but this is for India, definitely. So you see, can I put this here? How it's on the rise. I just want to. Yeah. So this is just one medical technology. You can also have analysis, biotechnology, right? So we put biotechnology and you do line medical technology, update chart. So we've got two now. In India, we are looking at medical technology and biotechnology. So we are looking at European patent applications which have been filed from India. Okay, so you see how it is going. So you've got biotech 2017 onwards, there seems to be a little bit of a plateau, and we're looking only at applications. You want to look at grants, it would be different. So basically, for you to see how one arrives at all this data, these things are available. This I'm showing you at the European Patent Office. All right. So now here we are looking at grants. You can see there has been a dip in 2019 when it came to biotech. Can you tell me what is the reason for the dip? Anybody can tell me what would be the reason for the dip in biotech? Excellent. COVID in 2019. And how has there been an increase in the medical technology? You see a rise. What is the reason in the, you can see it's a mirror kind of a thing. Why is that? The reason is the same.
ಗೊತ್ತಾಯ್ತು ಆದ್ರೆ ಅದಕ್ಕೆ ಇನ್ನೂ ಮೆಡಿಕಲ್
Absolutely the same reason, right? You cannot have research in biotechnology, but you need to have some kind of an applied thing because we had to apply it to the time. So medical technology was on the rise. So these are some of the things I wanted to share with you. Now I want to show you my slide. Okay, so now how do I go next? Enter. Okay, so here I'm looking at the global scenario now. There is a class called C12N508. This is a classification. This is basically for biology and tissues and cells. I wanted to take this because this classification I chose because we are talking about biotechnology. Now you see, this one, it poses very significant bioethical questions. Now, the patterns of ownerships and ways such patents are used are likely to be subject to special scrutiny from a bioethics point of view, right? So now you see in most countries, there was some kind of a peak in 2012 and a sudden dip after that. I haven't got the data. It can be easily sourced from any of the databases, but the screen is only so much and I wanted to show you the entire thing. This is an international patent activity chart. So why do you think this dip happened? Anybody? Any answers as to why this dip happened? Changes in laws, exactly that. It affects research, you see. So let me go back. Here in 2019, you can see there is again a little bit of a hump, right? In Europe, a little bit of an increase. And then again, it goes down. Now, I'll tell you, I'll read it out to you so that you have all the details. You see, biotech patenting in 2019, after a small increase in 2018, saw about a 15% uptick in biotech. Stanford, MIT, they were the most active standalone universities for biotech patent. Harvard leading the way with the most cited patents. However, the University of Tokyo also scored well as a result of patents related to regulatory T-cell research. Yale re-entered the top 20 for the first time since 2014, thanks to older patent finally clearing the US Patent Trademark Office. The Mayo Clinic made its first appearance amongst the top 5 research institutions on the strength of new patents focusing on nanobody antibody complexes. Seoul National University joined the list. United States has led the way in overall patenting, etc. So these are all the things. However, let us go back to this. Why did this dip happen and what was the change in law? That is what we want to address right now. Can I see the Okay, so I'll tell. So what happened was, this was the time when, the patenting of genes and DNA and all these became an ethical question. In 2012, this was in very much in the press and media till 2013, 2014. And most countries, they said, like cloning, you cannot have patents for that. Genes, altered genes, you cannot have. And all this kind of, a lot of questioning and there is a lot of literature on that. That just brought the entire thing down. You see how high it had reached and how it came crashing down. Now with COVID, there was a little bit of a pickup. And what was the issued research biotech patents by country in 2019? You can see there is a comparison between the European Patent Office and the USPTO. Of course, the United States is the leader. EPO is much less, but you can see the comparison. There is a huge disparity between the United States, patenting in the United States by various countries. So a Japanese company filing in the United States or in Europe. So Europe was not giving biotech patents. Basically, there is a huge stringency in the European patent laws regarding bioethics and whether you can, genes and clones and things like that can happen or not. Okay, so this is basically what this is showing. Countries do research like Japan, France, Korea, China, United Kingdom, Germany, all these have their research, but where it is filed, USPTO filings are the maximum. And then who are the 10 most active non-US universities by number of issued biotech patents? You can see there is a comparison. University of Tokyo ranking very high. Okay. And here there is the competitive impact by country of inventors. Denmark and Switzerland, they rank first for both biotech and all patents. All right. So this is how the global scenario of biotech patents is. And now this is the innovation index. All right. So GII ranks 1 to 5. You can see United States, Canada, and all that. India, today it is ranking 48. Okay. China is at 17. The biggest blob you can see over there is, you can see in 2020, there is US, Canada, Germany, that is the biggest one. And the technology relevance, that is the chart below that. The bubble size represents the patent asset index of the respective portfolios. Patent asset index means one technology has many patents to cover it. It doesn't, one technology is not limited to one patent. To make a technology, you have to have a portfolio, and that entire portfolio makes a patent asset index.
Ma'am, we can't hear you, ma'am.
Further, strengthened by patentable subject matter, enablement, and morality. Okay, so now this is the other question that the Indian Patent Office very, very often raises about biotech patents. All right, now just to refresh and to know that you are with me, can you tell me where in our Indian law do we deal with patentable subject matter? Any answers, please? Where in our laws do we deal with patentable subject matter? Nobody's answering. We need to know, where do we deal with patentable subject matter? Any answers? Under what sections do we deal with patentable subject matter? No, okay, it's section 3 of our Indian Patents Act. Okay, so there is specific exclusions to patentability, and there they say which are the points which cannot be patentable. What do we mean by industrial applicability? how well it suits. Okay. Okay. So basically, whether it meets a need in the country, whether there is a need for what you are giving to the patent office. And what is the criterion of novelty? What is the criterion of novelty? Novelty is absolute. The requirement is absolute new idea upgradation. Yes, that is absolutely correct. The requirement is absolute. It has to be new, and not new just in your country. It is new anywhere in the world. So let us say you are making, let us say you're making a tire or you're making a wheel. Okay, and you are talking about a wheel, then would the prior art, right, which is relevant to the wheel, like let us say there is a cave painting of a wheel, would that constitute prior art concerning the wheel you are submitting to the patent office? It would. It would, depending on how far you have gone from that initial wheel. Okay, so you have to keep in mind that any kind of recorded evidence that anything related to that what you're presenting to the patent office existed, it has to be, you have to acknowledge that. It can even be a comic strip. It can even be a newspaper article. These are all prior art, and it can kill your novelty. Inventive step. We dealt with inventive step. Let us just quickly refresh. What is inventive step? Inventive step towards novelty. Not quite. You clear the novelty filter first, and then you come to the inventive step filter. You might have cleared the novelty, but the examiner can pose a question on the inventive step to you. Why? Because there might be two different evidences which when combined, yes, which when combined propose a new step. Now, whether that would be obvious to somebody who is in the same domain as you or not, is that what would be questioned. What is enablement? What do you think is enablement? Not quite accessibility. When you write your patent document, you have to write it in such a way that anybody who belongs to your field, when tries to reproduce it, gets the result that you claim. So they are going to test it. It has to be testable. Basically, whatever you're saying, if it is done the way you say it has to be done, it should yield the result. Yes, it can be applied. Basically, that is what it means. So you are going to write out your invention in such a way that anybody else who is from the same field can reproduce it and get the results that you claim. Okay, so that is one of the most important requirements of patent process. Yes, it means reproducibility. That is what enablement means. Exactly right. The last thing is, it's a little ambiguous, which is morality. Now, morality being like, for example, using live human tissue for making a stem cell or something like that, that can create a controversy.
We can't hear you, ma'am. Sarasija, ma'am, we can't hear you.
Things which are related to morality, they can, make or break uh, a patent go through with special reference to biotech. All right. Why am I not going next? Okay. Okay, so now let us look at in India, what are the pharmaceuticals is another huge segment of biotechnology, and we do well. India does well with this. You can see where we have, this is just data between 2016 to 2018. I've not included 2019 because there many things have been happening since 2019. As we already saw, due to the COVID pandemic, things are a little difficult, but we will have all the data pretty soon. Okay, so now you look as of 2018, that is 2016 to 2018, CSIR was a top filer for pharma patents, followed by Dr. Reddy's Laboratories, ITC, MSN Labs, Lupin, Wockhardt, Cadila, Sun Pharma, Mylan, DRDO. So these, this is very heartening to see how much work happens in the pharma industries. And what kind of technologies in pharmaceuticals? Drug combinations. I've given the patent classes, so don't worry about that now here. This is we just look at what are the top technologies in pharmaceuticals, because the thrust is on India and biotech. Drug combinations, anti-inflammatory drugs, plant extracts. Plant extracts, I think, would be of interest to you, because in the earlier talk given by your institution, it was mentioned that plant extracts and Ayurveda figure very prominently in your curricula. So here you see plant extracts in India as well has a very prominent position. Multi-drug resistant cancer treatment. You see here it is treatment, but it is pharma. That means it's probably a drug, not a method of treatment. So multi-drug resistant. So here it is herbal composition. So you have plant extracts, herbal compositions, two of those things which probably would be of interest to you. This is the entire pharma thing. And also
Sarasija, ma'am, again, we can't hear you, ma'am.
basically because it has a whole number of institutions under its umbrella, right? And a whole lot of biotech, medical, life science based patents are being filed. And ITC, ICAR, agriculture research, Colgate Palmolive, DRDO, Department of Biotechnology, Procter and Gamble, you see, big filer, Dr. Reddy's Laboratory. This is food, water, and biotechnology. Amity University is coming up. IIT Bombay is very prominent in food, water, and biotechnology. So this is something to keep in mind. And these are the assignees. And what are the top technologies in food, water? Testing and detection of microbes. So this is not health related, but testing, detection of microbes, you see. Health, low calorie foods, functional foods, nutraceuticals, all of that comes under the second heading. Purification of water, lots of technologies. Microbiology, lab procedures, cosmetic preparations, you see. These are all biotech related domains, and we have the technologies which are related. And this time period is between 2016 and 2018. And Bharat Biotech, I have put the filing trends here just so that, just for an interest, let's just to see whether we can sort of relate to what their filing trend was, since the co-vaccine has come from there, you see, and it has really peaked in 2018, 2019. You see the topmost thing over there. Okay, I think, and what are the technologies? It has viral antigens, reoviridae, salmonella, vaccines, growth factors, regulators, Bharat Biotech, just for interest. And now we come to something where we have to apply our minds to. Okay, this is the business model canvas and how you can benefit with, from patents that are happening all over the world. So here we have Mr. Mutua, who has a finished market-ready piezoelectric shoe phone charger. Okay, it is a pressure-based mobile phone charger, and the device is installed inside a shoe's inner sole. What happens when you walk? The motion exerts pressure on the piezoelectric crystal, and you are able to charge it. So there is a patent filed in the United States, and it was not filed in Kenya. So can Mr. Mutua use this technology in Kenya? That is my question to you. Patents are territorial in nature. Very good. So absolutely correct. The answer is yes. And that's what he did. So why am I telling you this? See, we are a growing nation. We are a developing nation. Resources are always a question, there is a crunch about, you need finance for filing, you need finance for conducting research, you need finance for marketing, and you need to prioritize how you want to use intellectual property. A lot of technology is available out there, and not everything needs to be filed in India. Now, if somebody has not filed in India and that technology exists, can you make use or sell it? Can I have an answer, please? Can I have an answer, please? If a technology exists but has not been filed in India, can you make use or sell it in India? Absolutely, yes. Very good. You can, because it has not been protected in India and it is in the public domain for you, right? So you can. So we are a growing country and we need to know the rules of the game. If we play the game right, we will be on top of it. So that's why I'm telling you this. Patenting is one thing and using patents is another thing. If we combine the two sensibly, that is where you can get your progress, right? So here, this is what Mr. Mutua does. He picks up that patent information in Kenya and makes his shoe phone charger, right? And how does he do it? He finds key partners, activities, resources, cost structures, all these things he needs to fill. And he fills all these things up because the technology is already existing and he has a going startup business, all right, from a patent that exists, not filed by him, filed somewhere, but of use to him in his country, all right. Now we take an example for COVID-19. Okay, there exists a United States patent, okay, and it is a mask which has a filter layer, and it is in these COVID times it is useful. We have to look at it from Indian point of view. Now look at it, it is being filed in the United States, all right. Now can we use the business model canvas with India in mind? Any answers? It has been filed only in the US. Okay, can we use it in India? Yes, yes, very good. It can be. Right, another example. So this is an application which is an antiviral formulation, nanomaterials and nanoparticles, okay? And we are looking at the application in the context of the business model. You look at its legal status, it has been filed in 2006 in Great Britain. And then Europe, US, Korea, China, it has a PCT application, WO, Japan, China, and JPUS. So WO is a PCT application which can designate a number of countries. Now you have to keep this in mind and look at this patent, right? And can the business model canvas be used with India in mind? Answers, please. There is a PCT application there. Keep that in mind and give me your answer. India is not excluded from the WO. India is included in the WO, absolutely included. What happens then? Then you have to check for what is its status in India. So if you look at the Indian Patent Office, you see that it has been filed under this application number. The title is virucidal materials, and you look at what has happened. This is the entire thing. You go to the Indian patent database called InPass. It's available, not very user friendly, but you can get information. So you see the last thing that has happened is in 2008 examiner's report, which has been uploaded to 2016. So the last activity on this database is 2016. So you go into that further, and what do you see? You see that he's saying, the examiner is saying that there is an application from Japan which discloses particles comprising zinc, titanium, reducing virus transmission, etc., and that it does not meet the novelty. You are requested to comply with the objections by filing your reply by 2014. Okay, and there has been some activity. We saw that in the previous one. When I went back and checked, nothing has happened, right? So it looks like they have not proceeded with the filing in India. All right. So then if they have not proceeded with the filing in India and they have abandoned the filing in India, can you make use of the technology? Yes, you can. All you need to do is confirm, right? You can. All you need to do is you need to confirm with the Indian Patent Office that it really is abandoned and that they are not seeking protection in India. And you complete your business model canvas, get all your key partners, activities, resources, right? And make sure that it is cost effective, easy to use, safe to use. Who would be the customer segments? Doctors, nurses, patients, etc. Design your cost structure and understand what your revenue streams will be, and you would be ready to go. So basically, this is all I have to share with you, and I would end my talk here. Any questions now?
Thank you, ma'am. Now the platform is open for Q&A session. The participants can put a question in the chat box, and the speaker can answer the questions.
I think there aren't any questions.
Students, you can ask your questions. You can directly ask instead of typing in chat box. Ma'am, we have one question from a student.
Yeah.
Yeah. How about ethical issues in relation to plants?
Yeah, so this is the thing. If it already exists, right? If it already exists, it cannot be patent. Also territory, where it does belong. We've had a lot of ethical questions regarding plants, for example, the basmati, right? And then the neem, all these things which were connected to indigenous knowledge and things like that. They were all resolved based on the fact that these were all existing prior to the patenting process. So which are the ethical biopiracy type of questions? This was raised, right? Like we had neem, and then what else did we have? Haldi. The turmeric case is a very famous one. So these things are also related to biotech. And now we have a
Okay, thank you, ma'am. Ma'am, we have a question from the. Excuse me, ma'am.
requirement. There is a requirement in the patenting process which says that you have to deposit that plant material or biological material which you have used. So these are the couple of things how we deal with biopiracy and ethical issues related to material from a particular territory.
Thank you, ma'am. There's one more query from the faculty. With respect to plant extracts, as you mentioned, we have many patents. Will a process of extraction or the whole mechanism of biosynthesis mechanism will be involved in the patenting?
So the biosynthesis, if it is something which already exists, is not patentable subject matter because it already exists in the plant. But if the extraction, the process of extraction is new, right, and not already known, then that is patentable subject matter. For example, iron ore, right? Iron already exists in nature. The ore already exists in nature. However, and if you extract iron from the iron ore, you will get which is new, then that is patentable subject matter.
Okay. I have one more, my personal question. Is the same process implemented for patenting with respect to COVID-19 kits and all? Because it is very short time. Is there any other process, ma'am?
The patent prosecution is the same process. You will file a patent application. There will be a formal scrutiny of your patent application. Then there will be a prior art search. Then there will be a substantive.
Okay. Yeah. Any more questions from the participants?
Okay. How do I make it big?
Ma'am, one more question we have. Yeah. How about, is there any patent being filed for disposing the masks and other things which are related to COVID-19 now?
I'm sure there are, but it's a question of patent search. You have to do a patent search and look at what is being filed now, and because it's an absolute need. It's a beautiful question,
Yes.
and disposal is a huge issue. So you just have to go to the patent databases and look. There's a lot more that I can tell you. If you have the time, we can go to the patent scope database, and I can show you how to do it, but we are short of time. What I would suggest is go to the patent scope database. In that, there are sections, like transport, for example, ambulances and things like that, disinfection, then kits, diagnostic kits, treatments. Whole classes have been allocated. So if you go and do a proper prior art search, you should be fine.
That's good, ma'am. We will do it. Thank you for the information.
No problem at all. Always here and ready to help.
Yeah, thank you, ma'am, for the insight into the patents and how to go ahead with it, and the worldwide scenario, how the things are happening with relation to pharmaceuticals and biotechnology. Thank you very much, ma'am.
I just hope you find it useful, and the links that I have shown, please go there and take a look at it yourself. Whatever is of interest, probe it, And I'm sure if you do your own research, it will be more satisfactory than my trying to tell you. And today it is X, tomorrow it will change. This is a very dynamic field. It doesn't stay static, it will keep changing. So you have to go and you have to look at it. But
Yes, yes, ma'am. Thank you so much, ma'am. Over to Pallavi, ma'am.
Thank you, ma'am. I now request Srimati Trupti A. Vadakeri, Faculty, Department of Biotechnology, to welcome and introduce our next technical speaker of the day, Dr. Brinda Verma. Over to Srimati Trupti.
Warm greetings to everyone. I feel it is my great honor to introduce our next speaker, Ms. Brinda K. Verma, IP Advocate, Patent Agent, Bengaluru, and Managing Partner, Ekam Legal Abroad Law Firm. On behalf of KLE Society Management, Principal KLEs is Nijalingappa College, Head Department of Biotechnology, Heads of various departments, Faculty, Department of Biotechnology, I extend warm welcome to Ms. Brinda K. Verma. She is a dynamic lady with eminent role in the society. Ms. Brinda K. Verma holds a MSc degree in biochemistry and biotechnology from Bangalore University. She has a LLB degree from Bangalore University and a postgraduate degree in business administration from Symbiosis Pune. She is a registered patent agent and qualified to practice before Indian Patent Office. Ms. Brinda K. Verma is an advocate and patent attorney with over a decade of experience in dealing with IPRs, including patents and trademarks. She is associated with research wings of several institutes to frame their IPR strategies. In the managing a partner of Ekam Legal Abroad, a law firm based out of Bangalore, which handles and assists business including startups in various legal matters from inception of a company to protecting their IP. Her primary focus areas are patent drafting and prosecution, IP litigation, training researchers of various educational institutes, and startups on various aspects of patent, trademark, and copyright related areas. She was associated with Intellectual Property Cell of IISc for over 5 years as an IP executive. She handled technology transfer deals for IISc inventions, drafting and negotiating research and license agreements, preparing, filing, and prosecuting patent design and copyright applications, and has managed outside counsels. She was instrumental in transforming the IP cell of IISc from a service facilitator to a service provider. She was involved in handling several research-based collaborations with industries. She worked towards pursuing a systematic, mutually beneficial engagement with research-based national and international companies in order to encourage them to partner with IIS. Thank you, everyone. Now, I request respected Brinda ma'am to enlighten us with your presentation. Over to you, Brinda ma'am. Ma'am, we cannot hear you, ma'am. Please unmute yourself.
Can you all hear me now? Am I audible?
Yes, ma'am.
Thank you very much, Dr. Trupti, and thank you, Kaylee and KCST for giving me this opportunity. I think before I start, I would just want to know how much time do I have to complete my session? Is it 1 hour or a little more than 1 hour?
1 hour, ma'am, but you can take as much you want.
As much, you should never give the description to the speakers.
It's 1 hour, ma'am.
Thank you. And after that wonderful session from Dr. Sarsija, I think I will, continue on the perspective of Indian context, basically of what does the Indian patent law talk about the biotechnology invention. So this would be the objective here for the next 1 hour. So I would be covering the following aspects. A little introduction about the patents, and of course you've already learned about it, but yeah, I think it's always important to start with that. A brief history of how the biotechnology patents have been developing in India. Patentability criteria from the international perspective, you've already learned that. So I will focus from the Indian side. Patentable subject matter and provisions relevant to the biotech industry. I also know that there might be an overlap, between what has been covered previously and this, but we'll try my best to ensure that the overlap is minimized. And a few case laws as and when required. So I don't have to get into the details of what is a patent. All of you are already aware what is a patent and what actually, what kind of a right you get under the patents. And so we usually call intellectual property rights as a negative right. When I say negative right, you have a right to stop others from making, using, offering for sale, or selling your invention for a period of 20 years. Okay, so that is what we mean when you say you have certain rights under the patent law. So with this, a little intro about patents. Let's try to understand inventions in biotech field. So it includes any kind of product or process, of course, as you know. Some of the examples which I picked up from the patents granted in India is gene engineering technologies, methods of producing organisms. You please try to understand it's a method of producing organisms and not the organisms per se, because there is some kind of restrictions there. So methods of isolation of microorganism from culture medium, methods of mutation, cultures, mutants, transformants, plasmids, cell lines for making monoclonal antibodies, transgenic plants, animals, isolation of human genes for using them to produce medicaments. So these are some of the inventions which gets covered in this particular domain. With that introduction, let me get into the brief history of how patenting in biotechnology has developed or is developing in India. So till 2002, the practice in the Indian Patent Office were that patents were not granted for inventions relating to living entities of natural or artificial origin, biological materials or other materials having replicating properties, substances derived from such materials, and any processes for the production of living substances, entities, including nucleic acids. So till 2002, this was not the scenario in the country, despite it meeting the patentability requirements. Okay, but patents could be granted for processes of producing non-living substances by chemical processes, bioconversion, and microbiological processes using microorganisms or biological materials. So that was definitely allowed even prior to 2002. However, what happened that all these things were started included in the Indian patent, pertaining to the grant of technology inventions. So one such interesting decision by the High Court, Honorable High Court of Calcutta, was that this is a case between Timanico versus Controller of Patents and Designs, where it focused on inventions where the final product of the claimed process contained living microorganisms. Okay, so this was the entire thing. So let's try to understand what this case basically dealt with. So the court, this particular case was related to a process for the preparation of a live vaccine for protecting poultry against bursitis infection. Okay, the control of patents had refused, that is, the patent office had refused the application for grant of patent on the ground that the vaccine involved processing of certain microbial substances and contained gene sequence. So the controller had decided that the claim was not patentable because the process was only a natural process, devoid of any manufacturing activity, and the end product contained living material. You can see what kind of conditions or the reasoning the patent office had given. So when it says it's related to a process for the preparation of a live vaccine, okay, so the controller said that it was not patentable because the claim process was only a natural process devoid of any manufacturing activity, and the end product contained a living material. So living material was not patentable. Now, one has to understand what the word manufacturer actually means, because the controller here clearly stated that it is devoid of any manufacturing activity. right? That is as per the definition given to us in the patent law of what invention is. I'll get into that a little later. So the court basically held that the word manufacture was not defined in the statute. Therefore, the dictionary meaning attributed to the word in the particular trade or business can be accepted if the end product is a commercial entity. Okay, so that is what the High Court went ahead to and tried to define the word manufacture. So the court held that there is no statutory bar in the patent statute to accept the manner of manufacture as patentable even if the end product contain a living organism. So the Indian Patent Office says because it's a living organism, you cannot consider that to be a manufacturing process. But however, the court said that even if this is a living organism, okay, you should consider that to be a manufacture. You know, it should come under the definition of manufacture. So the court came up with an interesting test, which was considered to be the vendability test to identify, what the invention is all about. So the said test would be satisfied if the invention resulted in the production of some vendable item, or it improved or restored the former conditions of a vendable item, or its effect was a preservation and of some vendable product. So the court further stated that the vendable product meant something which could be passed on from one man to another upon transaction of purchase and sale. In other words, be a commercial entity. That is what vendable product. The reason I had to read this out for you is because it is important for me to communicate to you what exactly the court had said, not something which I am trying to interpret. Okay, so considering that, the court concluded that a new and a useful art or process is an invention, and where the end product is a new article, the process leading to its manufacture is an invention. So can you just try to understand the difference here? So it said that a new and useful art or process is an invention, and where the end product is a new article, irrespective of whether it contains a living organism or not, the process leading to its manufacture is an invention because the end product is new, the end product is different. Now, based on this decision, in the year 2002, okay, the Patent Act was amended, and to basically incorporate biochemical, biotechnology, and microbiological process, okay, within the scope of so-called chemical process and within the scope of so-called manufacture. So here, because there's a lot of confusion, the definition of invention was changed in that particular year. And it said any new product or process involving an inventive step and capable of industrial application. So the manner of manufacture was deleted in the enactment, okay, for this particular thing. So why was it deleted? Because of this decision. The manner of manufacture was not very relevant when it came to since there was no definition provided by the Patent Act, so the interpretation is always a problem. Now let's move on to the patentable criteria, which has already been dealt with. So you know the primary criteria for patenting. So it is novelty, your invention. So what is an invention, which I've already said. So your invention should be novel, should be non-obvious, and should have an industrial application. So from the Indian perspective, I'll give you examples of how a patent office actually considers these three criteria, okay, and evaluates your invention. This is which I've already so what does an invention mean? It says a new product or a process involving an inventive step and capable of industrial application. So invention is related to both a process or a product, or it can be both. So this is something which is what I'm going to deal here in the next few slides. So let's go into the examples of novelty. I will not get into the details of what novelty is, what inventive step is, because the previous speaker has already covered these criteria. But I'm just going to focus from the Indian perspective of how they deal with what an invention is novel. So I'm just going to take an example of a claim, which we call it, I mean, we have different kind of claims or different kind of inventions. And based on the inventions, we have different kind of claims which you put. One of such claims is product by process claims. You know, the case which I previously explained. So that also falls under a product by process claims, wherein a claim to the claim reads as follows: a claim to a product obtained or produced by a process is anticipated by any prior disclosure of that particular product per se, regardless of its method of production. Okay, so some of the examples are a polypeptide compound, which is a product of the method according to claim 10. Okay. So a polypeptide compound, which is a product of the method according to claim 10. So what is it saying? Now, I have actually produced a product using the process which has been listed there. Okay, so that is what it means by a product by process. My product is achieved because of the process which I have mentioned in my previous claims. Okay, so I claim my product based on that. However, my product would not be my first claim. I would not say, the invention pertains to a polypeptide or a compound X. No, it doesn't say that, but it says in a polypeptide, which is a product of the method according to claim 10, right? A transgenic microorganism obtained by the method characterized in that. So these are some of the claims wherein it clearly states that you have obtained a product based on certain process which you have been followed, and that process is unique. So basis that you have achieved a product. Now, are such inventions basically accepted? Are such patents are granted for such invention? The question is, there is no doubt that a patent can be granted for the process which you achieve. Okay, the process which is new, if it meets the criteria. So the patent office will try to divide your claims. Okay, so obviously when somebody has gone ahead and drafted claims, they would have added two independent claims. One claim, the first claim is pertaining to the process, and your next independent claim is regarding the compound or a polypeptide or whatever you have obtained using this process. Okay, now, so if the product meets the requirement of patentability over the prior art, then of course a patent would be granted for your product as well. However, if your product is not new, does not meet the requirement of patentability over the prior art, then of course a patent will not be granted. Your patent probably will be restricted only to the process. Okay, so that is where the whole issue lies in. For instance, I'll give you an example here. Say we have obtained, I'm just giving a random example, paracetamol, okay, using a certain process. Now your process is unique. So you've come up with interesting steps, and then you have, obtained or produced paracetamol. Now what happens? You're going to claim paracetamol and you're going to claim the process as well. Process probably meets the criteria of novelty, inventive step, and industrial applicability. But then when it comes to paracetamol, which also I've claimed at the end, now how different is this paracetamol from the existing paracetamol? Now, if I get a patent for paracetamol, okay, paracetamol is already in public domain, which means I'm trying to monopolize my product of this paracetamol, okay, through this process. But it also means that if somebody else comes up with this paracetamol using a different process, they can also get it right. It's not restricted only to you. So what the patent office does is they also analyze this product to see whether this product, what you've achieved, probably using a different process, is also in the market or not. Now, considering that paracetamol is already in the market, so the technical effect remains the same. So that the patent office will reject the grant of, that particular claim related to paracetamol. However, if you can prove the technical effect is much different, so your paracetamol efficacy is much different, the features are much different from the existing paracetamol, then of course the patent office will consider and grant you a patent for that claim as well. So that is how it is analyzed when it comes to product by process. And in biotechnology inventions, you have a lot of such things, such kind of inventions where it is relied on product by process claims. The next example I would like to give is a sequence claim. So let's read this out. So it says a claim to a polynucleotide sequence that was available, example, as a part of library before the priority date. Okay, so it can lack novelty even if activity or function of the said sequence of the polynucleotide has not been previously determined. So what does it mean? So if there is a polynucleotide sequence available in the library before I filed for a patent, okay, and because it's available in the library, obviously it lacks novelty. Okay, now what have you come up with? If your invention is not focusing on the polynucleotide sequence, but focusing on a new function or a new activity of the polynucleotide sequence, even then it is rejected. It is rejected under doctrine of inherency. Basically, what it says is, now the new function or the activity which you have identified of a polynucleotide which is available in the library is something which was inherent, right? So it is not, it's a kind of a discovery. It's not an invention. So since it was inherent, a patent will not be granted. However, if it is not, if your polynucleotide sequence itself is new, then of course it's a different story altogether. And another example here is if any sequence of the polynucleotide or a polypeptide from a prior art does not exactly match with the claim sequence, okay, of what you have come up with. So if your sequence has some variation to the one which is already available in the domain, and when you try to compare, if the variation is very, very clear, then under those circumstances, it will not be considered, your invention will be considered to be novel and it will not be considered as anticipated by the prior art sequence. So those kind of sequences, of course, you can get a patent. Now that is with regard to the example of novelty. Now let me get into the details of an inventive step. So first and foremost, when a patent office considers for evaluating your invention, they'll go stepwise. The first thing they'll do is do a novelty check. Okay, and in the novelty check, they will determine whether your invention is disclosed in one single document. All the features of your invention, whether it is disclosed in one single document. Then after that, if they identify that it's not disclosed in one single document, okay, then they will go ahead to the next step with regard to the obviousness, that is inventive step. And then try to understand whether your invention is eligible as per the non-obviousness criteria. So as per the Patents, Indian Patents Act is what I'm trying to focus. An invention will have inventive step if the invention involves A, technically advanced as compared to existing knowledge, or B, having economic significance, or both, and that makes the invention not obvious to a person skilled in the art. Okay, so this is some of the criteria also to determine the inventive step. So let's take some examples here. The first one. An isolated DNA sequence encoding a mature human IL-3 protein having a proline residue at position 8 of the mature polypeptide, said protein possessing bone marrow proliferation inducing activity in a human bone marrow proliferation assay. So the difference with, as I told you, whether a novelty, inventive step, it is always evaluated using the existing prior art. So of course, if there's no prior art, the question of novelty or inventive step is not arise. So you compare the document, then on position 8, there was a proline moiety, whereas in the prior art compound, in the same position, there was a serine molecule. So that was the main difference. Position 8. So let's see what the patent office actually said. what I'm going to give you is not. So it's are part of family genes which are similar in their amino acid sequences, but are minor variants or point mutations of each other. So a single variation in the amino acid sequence does not normally change the activity and function of the protein unless the single variation is in a critical region of the protein. So look at the way they are trying to evaluate. So the applicant here could not provide any evidence that the protein coded by the claimed DNA was any different from that of the prior art in its chemical properties. Thus, the inventive step cannot be acknowledged. So by only changing one position, okay, and replacing it with a serine molecule as opposed to a proline moiety, the patent office said that unless you do not prove, okay, that there is a change in the activity and function of the protein with this single variation, we cannot basically state that it has an inventive step. Okay, so these are the conditions which the patent office put. So please understand these conditions are applied even for any new inventions which you file for a patent. So this is a precedent which patent office will follow for all their inventions, and this is how they go ahead and analyze when it comes to the sequences and the function these sequences have or the sequences carry. The next example here is a recombinant DNA sequence of sequence ID number whatever 10. So encoding sequence ID number X, encoding human interferon alpha 2 polypeptide. Okay, so this is a claim. Now, prior art discloses a nucleic acid sequence of sequence ID number X1 encoding human interferon alpha 1 polypeptide. Okay, let's look at the analysis here. So my claim, my invention is I come up with a sequence ID which encodes human interferon alpha 2 polypeptide. The prior art talks about the nucleic acid sequence of sequence ID X1 encoding human interferon alpha 1 polypeptide. Now, the claimed human interferon alpha 2 is structurally close to the prior art's human interferon alpha 1. So this is what the analysis by the patent office was. However, the alleged invention can be held non-obvious. So which means they said that it is inventive in nature because of the fact that the claimed human interferon is 30 times more potent in its antiviral activity than its prior art analog. So you can understand the difference, the functionality, there is efficacy is much higher. Okay, so because although they're structurally close, but however, because that the human interferon is 30 times more potent in its antiviral activity than the prior art of interferon alpha 1 polypeptide, it was considered to be non-obvious and a patent was granted. That is how the inventive step is analyzed. So let's move on to the industrial application. Okay, I'm just giving you one example each because there's a lot of things for me to cover pertaining to the biotechnology inventions based on the patent law. And since I have only 1 hour, I thought it's important and to just give you one example so that you understand how the patent office evaluates vis-a-vis the Indian patent law. So moving on to the third criteria, which is the industrial application. Now, what does this say? So capable of industrial application means with regard to an invention that it is capable of being made or used in an industry. Okay, so that is what it means. So it should be capable of being made or used in an industry. So it also says, our enactment also says that if a patent is liable to be revoked if the invention is not useful at any point of time. Okay. So let's take an example here. The claim reads as follows: a polypeptide in substantially isolated form comprising a contiguous sequence of at least 10 amino acids encoded by the genome of hepatitis C virus and comprising an antigenic determinant where HCV is characterized by a positive stranded RNA genome, to said genome comprising an open reading frame encoding a polyprotein, and 3-set polyprotein comprising an amino acid sequence having at least 40% homology to the 859 amino acid sequence X. Okay, so that to the 859 amino acid sequence X, so it is a number of amino acid sequence which basically it says it has at least 40% homology. Now, analysis by the patent office. So the patent office said that it was sufficiently enabled and its use was properly established in the specification. Therefore, this claim 1 was allowed. Okay, there was another claim which continued. So claim 1, there was no problem. It says because all the criteria was met and and approved in the specification. So the other claim actually says a polypeptide in substantially isolated form whose sequence is shown in one of sequence IDs 1, 3 to 32, 36, 46, and 47, or whose sequence is encoded in a polynucleotide selectively hybridizable with the polynucleotide as shown in any one of the sequence IDs 1, 3 to 32, 36, 46, or 47. Okay, so this was another claim. Now, the patent office examined and it said that the claim covered an almost vast number of polypeptides for which no use was established. And the said claim, because no use was established for the listed polypeptides, okay, I mean, the patent specification should actually clearly establish the use of each polypeptide, right? What is it used for? So for which no use was established, and the said claim therefore was not allowable on the ground that it lacked industrial applicability. Moving on. So fragments or ESTs are allowable if they, in addition to other conditions, satisfy the question of usefulness and industrial application. So probably when you're trying to claim any kind of fragments or ESTs, the patent office is very clear that if you can satisfy the question of usefulness in addition to the novelty and inventive step which I mentioned, of course it will be allowed. Now, but however, if you say that this EST is used, okay, as a gene probe or a chromosome marker, then of course it will not be considered to be having an industrial application. You'll have to be very specific, and a substantial use of the EST should be disclosed. So even in the previous case, the same thing has happened. Okay, unless you're very specific and specific with regard to the use of that is not disclosed, then it will not be granted. So one such example is to diagnose a specific disease. So you just mentioned what is the specific disease when I talk about a probe to diagnose a specific disease. So if it's a chromosome marker, we'll have to determine for what is it used for. Okay, clearly mention what is it used for. So when that is very, very clearly established in the specification and in the claims, then of course it will be considered that it has an industrial application. But if you give a general thing stating, okay, this can be used as a chromosome marker, no, the patent office would reject, stating that it is very generic in nature. Moving on to the patentable subject matter. So in addition to the important criteria of novelty, patentability, and industrial applicability, your invention, whether it's biotechnology or non-biotechnology invention, should not fall under the patentable subject matter. So here I'm trying to cover the sections which are relevant to the biotechnology industry alone. Okay, I'm not covering all other relevant sections because that is not the subject matter of today's discussion. So what does section 3B of our Indian Patent Act actually says? It says inventions contrary to morality or which causes serious prejudice to human, animal, or plant life or health or environment. So if inventions fall under this category, irrespective of whether it meets a criteria of novelty, inventive step, and industrial applicability, a patent will not be granted. For instance, a process for cloning human beings or animals. Okay, a process for modifying the genetic identity of animals which are likely to cause them suffering without any substantial medical or other benefit to man or animal. A process for preparing seeds or other genetic materials comprising elements which might cause adverse environmental impacts. Okay, so these are some of the examples under this category where inventions, a patent will not be granted because it will be considered to be against or a prejudice to environment or health, whether it is human health or non-human health or any living organism. The next section is section 3C. Okay, so a case study there. So here it talks about discovery of any living or non-living substance occurring in nature. How does one really identify microorganisms, nucleic acid sequences, proteins, enzymes, compounds, etc., which are directly isolated from nature and not patentable subject matter? Please remember that this is one of the exclusions which is not restricted only to India, but there are several countries who follow this. Okay, and I'm sure the previous speaker has spoken to you about a few interesting case studies which was decided by the US Supreme Court, which clearly spoke about how do you really differentiate between a discovery and invention of a living or a non-living substance. So products such as microorganisms, nucleic acid sequences, proteins, enzymes, compounds which are isolated cannot be considered to be a patentable subject matter. So one of the cases again dealt by the Indian Patent Office. So as an bacillus species, it's given an ID 123 comprising rDNA, sequence represented as sequence ID number 1. So the response from the Indian Patent Office was the subject matter of claim falls within the scope of section 3C of the Act as it attempts to claim an isolated bacillus species 123, okay, occurring in nature, that is from soil as disclosed in the specification. Thus, what is claimed in the claim is treated as a discovery of living thing occurring in nature and hence not patentable. Okay, so it was just a isolation of the gene sequence, and considering that, they said it is not patentable. Now, section 3D, very, very important. So mere discovery of any new property or new use for a known substance or of the mere use of a known process, machine or apparatus, unless such known process results in a new product or employs at least one new reactant. So if there's any invention which falls under this category, which will be considered as only a discovery of any new property, okay, without it showing any new reactant or any new substance in it, then of course it will not be patentable as per section 3D. It also further explains with regard to salts, esters, ethers, etc., etc. So, which is more towards the chemistry aspect, but complexes, combinations, and other derivatives of known substance is also considered for biotech industry. Okay, so anything falling under this explanation shall be considered to be the same substance unless they differ significantly in properties with regard to the efficacy. So the highlight here is about the efficacy. If you can do that, prove that, then of course you can overcome this particular section 3D. Now let's try to see a case here. Pre-protein A being one of the factors which primarily controls glucose metabolism in mammals having C-peptide, wherein said C-peptide comprises 2 amino acids selected from XY, YZ, and ZX. Okay, so this is what the claim is. Now, analysis. Prior discloses modified protein A having C-peptide. Okay, so wherein said C-peptide consists of amino acid XX. So here we have, my claim is a pre-protein A being one of the factors which control glucose metabolism in mammals having C-peptide, wherein the C-peptide comprises 2 amino acids selected from XY, YZ, and ZX. Okay, any one of these 2. Now, analysis, my prior art says that a modified protein A having C-peptide, wherein said C-peptide consists of amino acids XX. Now, the applicant failed to demonstrate any therapeutic efficacy as a result of claimed modification of the prior art. Okay, because there is no increase in the efficacy for the modification made. For the insertion of the two amino acids selected from the list of X5, YZ, and ZX, the patent office rejected this particular patent, stating that it falls under section 3B of the Act. So again, it is the end result, which is what is focusing on. Now, section 3E. This basically talks about substance obtained by mere admixture resulting only in the aggregation of the properties of the components thereof or a process for producing such substance. So an invention which is a substance obtained by a mere admixture resulting only in the aggregation of the properties of the components thereof or a process for producing such substance. So just gave a random example here of a combi flame, which is a admixture of paracetamol plus bruphene. So antipyretic and analogous. So such combinations, you would not get a patent. However, if the combination gives you synergistic properties, okay, and then it'll definitely be considered to be patentable. Okay, so the focus is here on the synergistic properties. An example here. A composition of innovative combination of dormant spore of naturally occurring Pseudomyces lilacinus and Arthrobotrys species fungus with enzymes, fats, and growth promoting molecules to control plant parasitic nematodes. Okay, now the patent office stated here that the claims fall within the scope of section 3E. Why? Because it is focusing on two naturally occurring fungal species. Okay. Upon examination, it is found that the claim is directed to a composition of two known fungal species. So said two species used in the alleged invention were known for nematode biocontrol activity. However, the specification was silent on advantages of a combinative effect of these two fungal species. So the synergistic effect was not proved. And because it was not proved over the sum of their individual effects, okay, the patent office rejected this claim under section 3E. Next is the section 3H. Now, 3H is related to inventions which are a method of agriculture and horticulture. So I've just given some examples here. A method of growing leguminous plants as intercropping for improving fertility of soil by augmenting plants as intercropping for improving fertility of soil by augmenting nitrogen content of the soil. So the patent office evaluated and said that the claim is agriculture method and hence falls under the scope of section 3H. So I think there is nothing new with regard to this method, because leguminous plants are usually grown as intercropping, right? We all know what is the importance of this leguminous plant when you use it as intercropping. And considering that, even if you come up with a process, the ultimate effect is you're using these leguminous plants to improve the fertility of the soil. So since it's a method of agriculture and horticulture, they said it's not patentable. Another example for 3H is a method of reducing mycotoxin contamination of a plant or harvested plant material that involved treatment of seeds with the chemicals before sowing or during sowing or the field for the plant cultivation process. Okay, now invention, because it only involves treatment of seeds with the chemicals before sowing or during sowing. They said that this is related to the cultivation process, falling under section 3H and hence considered not patentable. Section 3I. So this relates to method of treatment and diagnosis. Again, this is something from the TRIPS. So followed by all the TRIPS signatories. So any invention which is a process for medicinal, surgical, curative, prophylactic, diagnostic, therapeutic, or other treatment of human beings or a similar treatment of animals to render them free of disease or to increase their economic value or that of their products. So inventions falling under this category is not patentable. However, if there is any surgical, therapeutic, or diagnostic apparatus or instruments, okay, if it's related to an instrument or apparatus, of course, it's patentable. But if it's not related to an instrument or apparatus, and it's related to a process, then it is not patentable. There's always a lot of concerns when it comes to the latest technology, sometimes where you come up with an instrument which requires unique methods to handle the treatment. So under that, there is always a concern whether that particular apparatus, which is patentable as per the Indian patent law, along with that method to use that apparatus, should also be considered patentable or not. There's a lot of debate because sometimes it is acceptable, sometimes it is not accepted by the patent office for stating that the second part falls under the 3I, but the first part is of course allowed. Okay, that is still which has to be considered by the Indian Patent Office to see how we can overcome such kind of combinations. So removal of cancer tumor, removal of dental plaque and caries, surgical processes, blood transfusion methods, all these are not patentable as per Section 3I. So one example here, a method of monitoring drug response in a patient suffering from cancer treated with a combination of gemcitabine and P1446A, comprising detection of a gene signature with at least 2 drug response markers, wherein the said drug response markers are selected from the group consisting of P21, REV3L, etc., etc. So these are the various markers. So when we say from the group, which means you can use any one of these markers, right, to detect the gene signature. Now, and the patent office came back and said, the subject matter of claim is directed to method of diagnosis of human beings or animals, which are statutorily barred from the patentability under Section 3I of the Act, right? So since it is involved in the diagnosis of patients suffering from cancer, it was not considered to be patentable. So one of the smart ways to address this, you just remove this, a method of monitoring drug response. Okay. So, but however, if there is a way out to redraft the whole claims and come up with a claims which focuses on the compounds here, then probably we hold a better chance of getting a patent granted. The other exclusion is Section 3J. That's plants and animals in whole or any part thereof other than microorganisms, but including seeds, varieties, and species, and essentially biological process. Okay, so this again, any microorganisms, you can see the differences here. Other than microorganisms, okay, is something which will be falling under Section 3J. So one of the example here is a method of producing at least one of substantially pure hybrid seeds, plants and crops, comprising the steps of I, producing a male parent, which is a male fertile, 2, breeding the male parent with a female fertile, which is substantially male sterile, and 3, harvesting seeds from the female parent, which contain pure hybrid seeds. I think this method is anyway common. Any agriculturist who knows something about agriculture will have to do this for breeding. So here, the claimed method involves a step of crossbreeding for producing pure hybrid seeds, plants, and crops. Thus, it is an essentially biological process and not allowable under Section 3J, right? So that is how it was decided and said a patent cannot be granted. I think each example will give you an analysis of how random patents are not allowed by the Indian Patent Office. And in fact, we would say some of these exclusions are the best over such inventions. If at all this Section 3J was not available, probably a patent would have been granted for a crossbreeding mechanism, which is quite well known amongst the agriculturists. The other one is Section 3K, which is computer programs per se and algorithm mathematical methods. Okay, so here A computer-assisted method of generating a compound that inhibits the glutamine formation active site activity of a glutamine synthetase polypeptide, wherein said test compound is capable of inhibiting the interaction between an adenylated catalytic triad site of the glutamine formation active site and a glutamine phosphate intermediate, or of inhibiting the interaction between a deadenylated catalytic triad site of the glutamine formation active site and a glutamine phosphate intermediate. Okay. So this is basically related to a computer assisted method of generating these compounds that inhibit various glutamine formation. Now, what are the steps of providing a three-dimensional structure of a glutamine formation active site of a glutamine synthetase polypeptide? So it is all a three-dimensional structure and designing based on the three-dimensional structure. Since it was a mathematical model, okay, the patent office has rejected this invention. It said it's considered as a mathematical method or a computer program per se. Okay, so it is a method to design the inhibitory compound based on 3D structures, but does not lead to a real product whatsoever. So since it is not concerned to a real product, it falls under section 3K and it cannot be patented. That is what this particular enactment says. Section 3P. This is the last exclusion available for biotechnology inventions under the patentability subject matter. So section 3P talks about inventions which are in effect traditional knowledge or which is an aggregation or duplication of known properties of traditionally known component or components, is not considered to be patentable. Okay. One example is serum of pigeon possessing the anti-paralysis activity. So this was a claim. Now, I'm not sure how many of you are aware that I think it is it was a well-known traditional method of using the pigeon serum to cure anti-paralysis activity. So the patent office came up stating that the use of pigeon serum for the treatment of paralysis is a traditional knowledge in India or is an aggregation or duplication of known properties of traditionally known component. So they came up with interesting prior art where it stated that animals and the products utilized as medicines by the inhabitants surrounding the Ranthambore National Park. Okay, and this particular application clearly disclosed that the use of pigeon blood for treating paralysis. So they came up with a prior art and stated that since it is a traditional knowledge, it is known in the public. Because of that, a patent cannot be granted for such inventions. So that is with regard to the patentability criteria. Now, I think it's also important for us to understand the other clauses which are relevant to biotech industries. Of course, this is something which is relevant to all industries, but biotech industry also, it is important for you to know. Also considering the pandemic situation. So India also has several balances and checks when it comes to drugs or anything related to such a pandemic situation which we are facing. So one such option is the compulsory licensing provisions. Not many countries have, but yes, there are several countries who have included such an option in their patent systems. So what happens now under this? At any point of time, if the patent office thinks that this particular invention which has been patented by one particular country, one particular company is not meeting the requirement of public, or the cost is very, very high, okay, or is not working in a particular area, then under those circumstances, the patent office will go ahead and, without the permission of the original patent holder, grant licenses to other companies who would be capable of going ahead and producing these particular drugs, okay, to meet the requirement of public. So that is what it means, okay. This is just an overall description, not getting into the details, but then this is a great check which we have under the Indian patent law. But of course, there are certain terms and conditions which needs to be met for a compulsory license to be granted. So if any one of you have a doubt stating that, okay, why is that the current vaccines which we have for COVID, not being able to is not being manufactured by several other companies. One of the reasons is compulsory license is only for once a patent is granted. Okay, and after the expiration of 3 years from the date of grant of patent. Okay, there are a lot of issues involved in it, but I'm just trying to give you that. So of course, still, probably they would have just gone ahead and filed for a patent. So patent should be granted, and then upon expiry of 3 years is when this can be implemented or enforced. So this is one of the condition here. So I think, unless one does not fulfill these criteria, licenses cannot be granted. Now, other provisions, sufficiency of disclosure and the best method of performing the invention. It's very, very important for, biotech invention. Now, if you do not disclose sufficiently or the best mode of performing your invention, a patent would be rejected. So it is like, even if it meets the criteria I just specified or falls beyond the subject matter, okay, does not fall under the exclusions, and if you have not disclosed it sufficiently and not disclosed the best method of performing the invention, patent will be rejected. Now, deposition of biological material, I think was already discussed, but I'll tell you, it is a compulsory thing even under the Indian patent law. So you will have to go ahead and deposit the new biological material which you have come up with. Okay, you'll have to describe that clearly in your patent application and go ahead and file for application and deposit with any of the international depository authorities. We are all bound by the Budapest Treaty, and India is a signatory to this. Okay, and the process is very easy. It is not difficult at all. And the scientists from these collection centers are very, very helpful. And if you deposit it in one center, the same deposition number can be given to all other countries, to the other patent offices, wherever you intend to go and file for a patent. It is not a requirement that you'll have to go and deposit it each country's deposition center. Okay, but it is a mandatory that you have to deposit any kind of biological material which you have come up with, which you're trying to claim a patent for. With clearly characterizing the material which you are trying to put your hands on. Okay. In India, we have the MTCC, which is a microbial type culture collection, and Gene Bank Chandigarh, and we also have the microbial culture collection in Pune. So these are the two places where you can go ahead and deposit the biological material in India. All the details are available in their website. And if you do not deposit, of course, the patent will not be granted till you deposit and get your accession number from these centers. Another interesting aspect which everybody should consider, because the patents are being rejected because of not following this process, is biodiversity related issues. So we have something called a Biological Diversity Act. Okay, under this act, any intellectual property, including patents, okay, which is based on the research, understand, research or information on biological resources obtained from India shall not be granted without the approval of NBA. Okay, so that is what, which is very, very important. So you will have to go and file for an application before the NBA authorities. And then before your patent office examines your application, ideally, you should get a no objection certificate from the NBA authorities stating that this biological sources can be, a patent can be granted. The objective here is to basically facilitate the access to the benefit sharing. I would not say all the biotechnology related inventions might fall under this, but there are a lot which falls under this category. Even the research also includes that. I will give you one interesting case, pertaining to turmeric. So there was this scientist who was working on curcumin, and we all know that turmeric is available across. Okay, and this scientist has actually picked up this. He's not picked up the turmeric from naturally available places. But what he's done is, and not extracted curcumin from a plant, but he's basically bought this curcumin from a chemical store, a chemical store which is like well known in the world. Okay, so then he's gone and picked up this 100% pure curcumin for his research. Now, the research results are definitely different, but he's used this curcumin from there. Now, the NBA insisted that we should have sought permission from them and a no objection, because we are actually doing a research using a biological resources available in India, okay, for this particular invention. Now, because of that, there was a lot of issues which have to be faced by this inventor, and some of the inventors who were actually working this area, it was rejected, so they didn't grant they didn't issue any new objection. But yeah, some of them took the benefits because there's there was a notification 2 years, 3 years ago that all such things should be considered and quickly disposed of. So benefits were taken under that notification. But however, what was learned is whether you use it for research, okay, whether you extract it or not extract it, but obtain the purified form of this product from any kind of a store, you will have to report to the NBA. And of course, the process is again not very complicated. You can just report to the NBA. You are supposed to sign certain documents stating that if you reap benefit at some point of time, if you're trying to extract curcumin from turmeric plants, instead of then buying it, maybe you can always think it this way, that probably when it is mass production, buying the purified form, the 100% form from a chemical store may be expensive, and you would consider going ahead and sourcing it from some store, sourcing it from a farmer. So under those circumstances, they're like, we will have to share some kind of benefits with them. So that's the objective here. And it also, another objective is to prevent misappropriation of biological resources and traditional knowledge, which is also happening with a lot of industries, both pharma and biotech. And this has actually put in a lot of checks and balances and has ensured that the biopiracy also does not happen. With this, I would end my session, because the other case laws here would have already been covered from the international perspective by the previous speakers. So whether it is Mayo versus Prometheus, which talks about how various drug-related inventions, and the myriad genetics, which actually spoke about the extraction of a gene, whether it is considered to be patentable or not, whether it's considered to be a discovery or an invention. Okay, so these cases have already been discussed. I will not get into the details, but and would like to restrict only to the Indian patent law cases. So this is a quick statistics. This is from the report by the Indian Patent Office. You can see the number of inventions which are being filed in India. Unfortunately, the numbers are not very high. Engineering domains, of course, the numbers are high, but you can see that in 14-15, the biotechnology inventions was 260, 215-16 reduced to 185. 17-18, 546 in this industry, and 18-19 again, it's come down, it's 457. So these are the number of patent applications granted in that particular year, okay, from 14 to 19. And number of patent applications filed, 15, it is 1,035. Now, one cannot correlate the patents filed and granted. So I cannot say that in 15,035 were filed and only 262 were granted. No, for a patent to be granted on an average, it takes 3 to 5 years. So probably there's 1,035 patents granted in that particular year of patent applications filed maybe in 2010, 2009, or 2011. Those years where patent applications were filed would have been granted in 2015. So the number was 1,035 then. In 2018 and 19, the number of patent applications granted is 882. Okay. the numbers have to be, the objective of all our sessions is to encourage and to give you that kind of analysis of the how patent law treats your inventions, evaluates your invention. And I think at least through this awareness, we would want you to understand that, you can keep in mind when you're drafting a patent applications or even when you're trying to work on a particular project to ensure that you meet the criteria in the beginning itself and do not struggle, after filing for a patent based on the objections raised by the patent office. So the objective here is to ensure that you go ahead and seek protection for your biotechnology inventions and increase a number in the country, which is unfortunately very small in nature. And again, out of this, there are very few Indian applicants filing these patent applications. A lot of multinational companies were seeking benefit here, but there are very few Indian applicants trying to file for patents under this domain, which is an unfortunate scenario. But I think the kind of awareness created by both the central and the state governments, we hope that in the coming years, the numbers would go up and many of you also would focus on filing patents in this particular domain and help the country generate some revenue using these patents. So thank you very much for your kind attention. I think we can open the floor for probably a couple of questions. I am sorry that I was quite fast without taking a break because I had to cover a lot of things in this 1 hour time. So that's the reason I was asking how much time we have in the beginning. So I was trying to be really fast to cover all these aspects, but however, yeah, maybe we can just take another 2-3 minutes to close. I know it is lunchtime and all of you, would be hungry.
Thank you, ma'am, for the wonderful presentation. Now the session is open for question and answer. Please drop your questions in the chat box. We have one question from the faculty, ma'am. What would happen to a patented microbe or a mechanism that showed ill effects after it got patented?
It can always be invalidated if it shows ill effects. Okay, the patent law actually is not restricted only to rejecting of a patent. At some point of time, if somebody can really prove that it has ill effects, it can always invalidate.
Okay, thank you. There is one more question from the faculty. What are the norms for biological protocol patenting?
When you say norms, did they mean by procedures?
Procedures and what are the certain rules that has to be followed?
Okay, so I think the entire session was focusing on what are the terms and conditions one needs to follow. Basically trying to tell you that these are the criteria which your invention should meet. Okay, one meets this criteria and you as an inventor feels, it has this inventive step, it is non-obvious, it has this industrial applicability and does not fall under the section 3, which I was trying to explain. That is your first step for you to go and file for a patent. The second step is, the previous speaker, I'm sure I've told you because she's an expert in that, the importance of doing your prior art search. Your prior art search is definitely related to your novelty and inventive step identification. So you as an inventor, do your first analysis. And once these things are met, then follow the procedures. And the procedures for biotechnology inventions, as I told you, is not very different from all other inventions. But certain conditions, like if you have a biological material, please talk to somebody, go ahead and deposit it. If it's related to the NBA, do it. The very reason why I'm stressing on this procedural aspects is, even if your invention meets all the criteria, okay, and if you do not this, there are a lot of inventions which have been rejected. Okay, keep that in mind. Follow these procedures and then go ahead and file for a patent. Procedural defects will not be, considered at a point of time.
Thank you, ma'am. There is actually one more question. Can a microbial extract or any microbial component that is having antimicrobial property or any anti-cancer property can be patented, not the organism, but the component of the microorganism?
the component per se, again, it might not be the microorganisms, but the component which is available in that particular microorganism. Okay, if you're just trying to extract that component available in microorganism, and then you identify that it has these kind of properties, I would say is it's a lot of debatable matter, because there are inventions which are allowed by some of the patent offices. There are also inventions which are not allowed. It also depends on how we smartly go ahead and draft those applications. But for now, for this session, I will tell you that let's consider that it will be patentable, but please be very, very smart in drafting your applications to ensure that it will not be considered only as a discovery. If you can try to overcome that discovery component, yes, you can definitely go and seek patent protection.
Thank you so much, ma'am, for your patient listening and providing everyone with the valuable answers. Now session will be moved on with Pallavi, ma'am.
Thank you very much.
Thank you, ma'am. That was a wonderful session. Now, this concludes our first day of the workshop. Thank you all for attending. We hope you have learned and enjoyed the day's presentations. I request you all to grace your presence tomorrow for the second day of 2 days virtual workshop on intellectual property rights and biotechnology with the link provided at 10:30 a.m. tomorrow. Thank you all.
Thank you, Brinda madam, for joining us.
Thank
Thank you so much.
Thank you. Bye.
Bye. We express our sincere thanks and gratitude on behalf of KLE management, principal, and heads of various departments. Thank you so much.
Thank you.
Dear delegates, now we are going to receive feedback link. Kindly give your valuable inputs in this particular feedback link. And tomorrow you will receive your e-certificate. Today you need to give your feedback of today's resource person, a talk and interaction. Tomorrow, when you submit second feedback, that time you'll receive your certificate. Thank you. Dear delegates, kindly fill day 1 workshop on IPR and biotechnology feedback. It's put on the chat box. Kindly give your valuable feedback. Thank you, everyone.